Welcome everyone. I am happy to have you here today. Um, we have our webinar on back to work, and today we have three resources from Lyons Companies, and Lyons is our benefits partner. We have Kevin Thomas, who is Vice President, and Kevin is our contact for GAA at Lyons. Diane Campanile, who is Director of Human Capital Management and Employee Compliance, and Megan Murphy, who is Employee Benefits Consultant. So we are going to be rolling out three new programs with Lyons next month, probably later in the month. The first one is an employee discount program through MetLife, and that'll be for personal insurance for your employees, like homeowners and auto insurance, which will be at discounted rates, a cyber liability insurance policy, and then also human capital management consulting and human resource support, which Diane will manage. So you'll get a chance to hear her speak today, but she will be managing that program. And again, we'll be doing most likely a webinar later next month, introducing those programs and then doing more to promote them as well, kind of rolling them out. So for today, if you could, please mute your audio. That way, if there's background interference or other things coming in, we don't distract everyone else. Use the chat box that's up in the right-hand corner, that little circle that's up there in the middle. Use that to ask any questions. I'll keep my eye on that as well. And we are recording today, so I will forward the recording out to everybody so that they have that information and can share it. It'll also be available in the newsletter as well as on our website. So with that, I'm going to turn it over. Kevin, you're still leading off, I believe.
Yes, sir. Yes, sir.
So one of the things I asked Kevin to speak about a bit was insurance coverage for liabilities. We're all going to be facing a new dawn here with potential for litigation and liability revolving around the coronavirus situation with employees. And I wanted Kevin to speak about this because usually you look at your insurance policy when you have a claim, and then it's often too late at that point in time to deal with something, whether it's covered or not covered. So I wanted him to speak a little bit about what everybody needs to be aware of, what they need to be, to look at to make sure that they have coverage. And if you don't have the proper coverage, making sure that if you so desire, that you get your coverage updated so that you have the backstop in case you have some issues. So Kevin, turn it over to you.
Thanks, John. I appreciate that, and welcome everyone. Good afternoon. So before we begin this return to work presentation, just wanted to disclose that the information we have here really is based on a lot of state and federal guidelines, and we're providing some information here as a way to help you shape a program that is unique to your specific organizations. As you're going along with and putting together these programs for your organization, there may be a need for you, to actually consult with an employment attorney prior to implementing these return to work programs. So in any case where you have a specific need or concern, we would always remind you that legal advice actually trumps anything we're going to say. So we would advise, certainly reach out to your employment attorney if you have any very specific questions about needs. So with that out of the way, wanted to dive into what it would look like from an insurance perspective when it comes to some of the issues that you might have to address when you're looking at a successful return to work program. And from an insurance perspective, there are just a few coverages you'd want to keep in mind. The coverages are things like workers' compensation coverage, general liability coverage, employment practices liability coverage, and in very select cases, directors and officers coverage. The workers' compensation coverage, this is what actually covers your employees in the event that they are injured or they contract an illness while in the performance of doing their job. Now, the information we're going to give you here isn't definitive information because every policy has different terms and conditions. Carriers and the risk bearers actually translate different contracts with language that may differ from what we're used to. So we would always advise you to go back to look at your policy or speak with your insurance advisor for true definitive answers. But what we have seen thus far is that in the event that an employee contracts an illness and it's during the course of their employment and can be proven to be during the course of their employment, there may be a potential workers' compensation claim. So, and again, I'll use the terms, there may be a workers' compensation claim. So that individual would have to show that there was that during the course of their employment, not when they, went out on the weekend and violated stay-at-home orders to go have a beer with their buddies, that during the course of their employment, it's where, and during their job is when they actually contracted that. So what we've noticed is that this is more prevalent in industries and in areas where there's been healthcare workers or large manufacturing facilities where someone is diagnosed and they bring the disease into the facility. General liability, what that coverage does is that's for external purposes. That's in the event somebody causes damage to someone else outside of your organization. And there's a loss in that perspective. So that's where, if you have people who are actually still going out and meeting with people, there could be potential risk there. So I don't know anybody right now who actually is still sending people out to meet with clients kind of on a one-on-one basis. Obviously, there's deliveries that are still happening and whatnot. But again, they would have to prove that this was due to your actions, your operations. If you have somebody who's ill and they cause someone else to take ill and contract COVID, that's where there could potentially be a general liability claim. Employment practices liability insurance, just like the name says, that is actually for any accusations that you violated employment practices. That's going to be a huge part of what Diane's talking about in her presentation, is the rules, the regulations set forth that you as an employer have to follow. So this is the insurance that helps you with defending yourself in the event that an accusation is made that you violated some kind of employment practices law. And this is what's going to help you kind of offset some of those legal costs. And then finally, the directors and officers coverage. This is a true financial loss. And what could happen is in the event that you have shareholders or if you have an ESOP situation, this is going to be a lot. This is going to be very, very rare, I think. However, there's still the possibility that someone says you mishandled the situation and you therefore created financial loss for our organization. And we are owners in some way, shape, or form. So we're going to go after the board and we're going to go after directors and officers of the organization for the way that they handled or mishandled the situation. So kind of in summary here, those are the coverages, the four coverages that if from an insurance perspective, to really look at, make sure that you're bolstering those coverages, discuss those with your insurance advisors, and just to ensure that you do have them in place and that the limits are sufficient to ensure that you have what's necessary in order to defend yourself against any potential risk. So that's enough for me from an insurance perspective. Nobody likes insurance and wants to talk about it, so I'm going to shut up now. And I'm going to hand the floor to Diane Campanile, who's going to really dive into the meat and potatoes of the regulatory matters that we're faced with at this point.
Thank you very much, Kevin. I appreciate it. Thank you, John, for having me today and having Megan and Kevin as well. So I wanted to make a few comments as we dive into the issues to resolve for a successful return to work. While there are many questions surrounding the when and how we're going to return people, it is for sure we're not returning back into the same workplace that we left. The question on how safe it is to return an employee back to work is ultimately a medical question, and whether or not your work site is conducive for safely operating during a pandemic following the guidelines that have been issued by the CDC, OSHA, DOL, the EEOC, and the World Health Organization. So today we're going to be talking about recalling employees, the rehire process, and the paperwork that needs to be completed, employee benefits, how they may have been affected, logistical preparations as far as physical spaces are concerned, policy reviews and updates, and finally, employee resources. Businesses that are preparing right now usually have a faster transition, it happens more smoothly, and employees feel as though you've prepared for them to come back to work. Addressing these areas may be the first thing to help your employees get back to work and help your organization get back to operations. I'm going on to the next slide, Kevin. So recalling employees. It is important to take a look at what your employee handbook says. The hope is that you've been in touch with your employees during the time period that they may have been out of your workplace. Planning will be subject to the change as we navigate through these unprecedented times. But please take a look at your employee handbook. Your employee handbook probably has some current guidelines on returning employees back to work. I'm talking about policies and programs in your handbook that can look like, returning people from a leave of absence, returning an employee once they've been not with your organization for a set time period. It's important to review these and any other policies that you may have which could impact the plan you put together in order to recall employees back after or during this pandemic. Also, collective bargaining agreements. So if you have a CBA in place because you have a union environment, it's typically outlined within that CBA what you should do, how you should do it, and bringing employees back to work. The same thought as with the employee handbook. It's important if you have anything within the agreement that may dictate the process of recalling employees under the CBA. Sorry, I'm trying to account for the sound that I'm hearing in the background.
I just muted that person, so I think we're good.
That's okay. So typically when you see a collective bargaining agreement in place, you see things like returning employees based on seniority, returning employees based on years of coverage. So that's important because we're going to go back to that in a little bit. Planning your workforce, making sure that as an organization, you first identify who are the most important positions that need to be back into your workplace. So making sure you have your reception there, your receptionist there perhaps, or what are those positions that allow your organization to continue to offer the products and services that your organization provides. Those employees who need to be on site, and then which are required to be on site only and for how long. Is there the possibility that you can work in shifts with your employees? Which employees are most appropriate to fill those positions? And like I said, talking about collective bargaining agreements, now comes the time period that you take a look at your employees specifically and say, we need a receptionist. We have 3 to choose from. Out of the 3 we have to choose from, who's the most appropriate to bring back to the workplace first? Taking a look at things like a retention totem. I use a retention totem, and if you've been part of any of my seminars in the past, it is when we decide which employees will be chosen to leave the organization first. The same is true when we talk about bringing employees back. Will we bring back an employee who's been with the organization for 25 years versus an employee who's been with the organization for 5 years? Will we take a look at the performance in the past 5 or 25 years that they've worked for our organization, it is okay for you to do that and to make those selections in that manner. The manner of making it as objective as possible will really be key to ensure that you're not being discriminatory in who you choose to bring back to your organization. That being said, after you've got your list of employees who've been identified as returning back to your organization, please take a look at the demographics of those employees to make sure you don't see any type of trend that you would not want to or that you cannot support. So consider transportation or job sharing opportunities that your employees could have. So if you've got some employees who can fulfill a position 2 days a week while another can fill it 3 days a week, is that an option for your organization? Does that better meet the need of having some employees working at least part of the time? As most of you have already encountered, there is the opportunity in many states, in most states, to collect partial unemployment benefits. Would that be ideal for your workplace? And finally, are there transportation concerns? Are there employees who still take the bus to work, maybe take a train to work? And if so, are those buses and those trains working at this time? And if not, will you work with your employees on how they can get to work? Because it would be very important to make sure that those employees we are recalling actually have the ability to show up to work. And I think an employer's job, an employer's responsibility is to allow and provide as much assistance to an employee as is possible. If not, consider the possibility that some of these employees may continue to work from home. I'm advancing to the next slide.
Diane, we have a question here.
Sure.
So the question is, with the fact that bringing back certain employees that might be a high risk for contracting COVID, that is a complicating factor in your totem. Is that something that legally can be considered, or is that not able to be considered, or do you have any comments about something like that?
Oh, I certainly do. I think you'll find that I rarely lack an opinion, and this one, this one's actually came up recently. It came up today, in fact. So it is important to note that we all know there's high-risk employees, or at least we could say that the CDC has identified employees who they've determined to be at high risk. Employees who are, say, 65 years of age and older. Recently, today, a case was adjudicated in Arizona in which an employee who was over 65 and was provided the opportunity to continue to work from home, the employer thinking they were doing that employee perhaps a favor in order to allow them to work from home. The employee was not pleased with the decision to go ahead and make a decision that they were, because they were high risk, they were not either entitled or capable of returning into the workplace. So my advice for you on that would be, I would treat all of your employees, even those who have high risk that you are aware of, and some things are easier to determine than others, invite employees back to work who perhaps have been with you for a long period of time. You're trying to reward them, certainly for the time period that they've been your employee. The fact that they're over 65, let them tell you that's an issue, as opposed to you saying, I'm not going to return somebody because having done so and looking at the time period that they've worked for me has put them over the time frame of 65. Because you could have an employee who started working for you at 55, who's been there for 10 years, where you can have somebody who started working for you at 20 and with 25 years would only be at 55. So I would make sure that those people who are at high risk request the accommodation of not returning to work from you.
Great, thanks, Diane.
Mm-hmm. So Kevin, I've moved on to, and I think you've moved with me, thank you very much. When you return your employees back to work, make sure you're notifying the state unemployment agencies. They need to know, and typically your payroll carrier will advise the state when an employee has been hired. That will also suffice to provide notification to the state unemployment agencies in most states. But I would check with your payroll carrier to see if they will notify the state, and typically notify the state when in fact you hire an employee. Typically they will. Here's my high-risk employees, and the reason that it's asterisk is for that very reason. It's asterisk because of the question that was asked earlier today and just a few minutes ago, and that was those high-risk employees, should we make special accommodations for them? Certainly if they ask, I would take a look at, is there the option to go ahead and telecommute? Is there the option for FFCRA? Work with your HR team or an employment attorney on the options that will be viable for your organization. Consider allowing them to go ahead and and work from home, or perhaps when returning to the office, is there an isolated area that would enable them to have additional protections or upgraded protections within their cubicle area? Do you want to go ahead and put things in place that would enable your employee to feel more safe when they return to the workplace? The FFCRA, for those of you who are not familiar, is the Families First Corona Response Act. So under the FFCRA, there are certain provisions that are allotted to employees. It's a federal law that was signed on April 1st into place. Employers with 50 or less employees have certain exemptions that they can claim should they choose not to participate with FFCRA. Employers with less than 25 employees certainly have an additional exemptions. So there's the option for an employee to take either paid sick leave or extended family medical leave under the FFCRA for the specific reasons that our federal government has provided us. Questions on that can come to me directly. We can have a conversation. Also consider employees who are unable or perhaps unwilling to return to work. Employees who are afraid, it's important to consider interacting and overlapping laws if applicable. These may include sick leave, state plans, FMLA, ADA, amongst others. It could be that a leave is appropriate for this employee. What are their options? It is important to note that OSHA has stated, OSHA's law is that if an employee has a reasonable and specific fear of infection that is based on fact, they can in fact refuse to return to work. So you as an employer want to make sure that you've prepared that workplace in such a way that no employee will be able to say, I am afraid because you have not properly prepared. I am afraid because you have not put the proper steps into place. So once you know you've put the proper steps into place, returning your employees has now become working with them, trying to work with them. Employee entitlement to unemployment insurance benefits will vary state by state. State guidance on unemployment insurance benefits entitlement is changing regularly. There was previously the option for employees who were afraid to return back to the workplace to actually file for unemployment. I saw originally those claims were being accepted. I have seen recently where those claims are no longer being accepted as employers are now proving they have taken the proper provisions to allow employees to return back into the workplace safely. It's very important though that you consider your state guidelines. As we know, unemployment runs state by state. So some have a little bit more flexibility than others. And finally, employees who have family obligations that interfere with their ability to return back to work. We know our employees. We know what employees, which employees this could include. And for those employees, it's important to know whether or not your organization is going to comply with the Families First Coronavirus Act, because they can have the option to be out on a leave of absence in order to care for their child 14 years of age or under who does not have access to daycare or school because of COVID-related reasons. And you'll hear me say because of COVID-related reasons often, because FFCRA is totally predicated upon that. I'm moving to the next slide. So your rehiring process. Employers will have to assess the need to go through all new hiring paperwork. The key to determine this need will be first to determine if in fact an employee was laid off or an employee was furloughed, looking at that to see if it's actually a separation of employment. It's dependent upon your jurisdiction perhaps, but employers will have to review if the employee has remained paid, if in fact they've been paid, if in fact they've remained on active benefits, or if they have been out of the workplace for less than 6 months, it's more likely that you can go through a rehire process instead of a new hire process. When it comes to an exemption classification, it will be important when returning employees, be sure that their exemption classification continues to be accurate. When I talk about exemption classification, I'm talking about under the Fair Labor Standards Act, is the employee exempt from overtime, or are they not exempt from overtime and therefore entitled to overtime pay? I have an FLSA questionnaire that I can make available to any of you if you would like to have one. It is something I recommend every employer use when they're hiring an employee to make sure your exemption status is correct for that employee, because as we all know, wage and hour claims are very costly. And I think we're going to see confusion when employers are bringing employees back to work. Also consider your drug testing policy and how it might be impacted by returning employees back into the office or your facility. If you do that as a new hire process, will you include that in your rehire process for those employees that we talked about have either been paid, have remained on active benefits, or have been gone out of your site for less than 6 months? Compensation. When you return employees back into the workplace, I recommend we use a recall notice. A recall notice looks exactly like, or looks very similar to, an offer letter. And the next slide has an example for you. But again, if you need a copy, I'd be happy to provide one. Consider what your organization is going to do about any annual pay increases that were not afforded during the time period that an employee was out and perhaps not working. Now that that employee is returning back into the workplace, are you going to go through the annual pay increase process again, or are you going to delay it for the amount of time that that employee has been out of work? I have clients who are considering hazard pay. I am now asking them to refer to it as incentive pay, because as we know, OSHA is very specific, the Department of Labor is very specific on those employees who are given hazard pay. And those are for positions that do not have proper protections under an OSHA standard. So that's important to note. Service-based awards. You know, we've been out of work. Some of us have continued to work while working remotely, while others have continued to go into the office or the facility, and then others furloughed or laid off. When it comes to service awards, consider what your organization is going to do and whether or not this time period will count towards their service time. Also, bonuses, the same thing. It is a matter of deciding, should we delay them for the time period or should we in fact award them? Before we started today's presentation, I did let John know that at the bottom of the slides where you see I have referenced a specific place in which I received the information that I'm speaking about. I am going to make a packet of that information available to each of the participants so that you can go ahead and review that information. Kevin, I'm ready to move to the next slide. So your recall notice. It is something I referred to previously. And if you take a look at this recall from furlough, it's a revised offer letter. And I'm very specific about making sure that I include the job title, the supervisor, and the responsibilities for the position that they are being called back to, the employment classification, and whether or not their seniority, especially where we have service-based awards, will or will not be affected. And my final paragraph there is, we're committed to doing everything we can to return you to a safe and healthy workplace, because remember, what I was concerned about, or what I'm concerned about, is that an employee would be able to cite an OSHA reason and say, for this reason specifically, I am not returning back into my workplace because it's not safe. So it's really important that you communicate with your employees. It's really important that you share what you have done to make sure that you've disinfected surfaces, you've got social rules that are being put in place, and don't forget training when it comes to those rules. So as I do with any offer letter, it is important to have the employee accept, or decline the return to work. As you know, when an employee has been provided with a position for which they can work and they decline returning to that position, they are less likely to be able to collect unemployment benefits should they say, I did not return to work, it was not the same job, I didn't have the same capabilities. Less likely, but again, remember discussion about unemployment earlier, it depends on the jurisdiction, it depends on the state. Where I've seen some flexibility with some states, I see other states declining that flexibility as we continue to move forward. I'm moving to the next slide. So your rehire paperwork. Everybody, when you're rehiring or hiring a new employee, you have to decide whether or not to use a new I-9 form. If you are rehiring an employee who has been on benefits, has been gone for less than 6 months, has perhaps continued to get paid in some manner, you can use the rehire portion, which is the re-verification section of your I-9. But when you bring employees back to work, if we determine that this is a new hire versus a rehire, for new hires, we want to make sure that they go ahead and complete Section 1 on the first day. We want to make sure they complete Section 3 within 72 hours. You can do this, they can do this remotely. So you can actually view their documents that prove their ability to go ahead and work with your organization. You know, each I-9 provides a listing of documents that's acceptable. You can, in fact, let them take a picture of the document, send a scan of the document. Unlike what we normally do, you can do this and be able to approve the person for hire. Once that person comes back into your workspace or is in fact at your workspace, you can then have them show you the physical documents themselves. So the differentiation for me here is it a new hire or a rehire? And if it's a rehire who's not going to be on site, it will be important for me to go ahead and fill out the I-9, but I'm still doing so remotely. If it's a new hire or rehire coming back into my facility, then I have no reason to have a picture or to have a copy. I will physically touch that document as the I-9 requires me to do so in order to be able to bring that employee back to work. Again, I have another reference at the bottom where this information was collected from. I'm ready to move to the next slide. And this slide's with regards to employee benefits. So my colleague, Megan Murphy, will be taking over for slides 8 through 11.
Thank you, Diane. And thank you, everyone, for inviting us to present to you today. So as Diane mentioned, I'm going to review some return to work guidelines regarding health benefits or employee benefits. These are guidelines, and we've tried to keep them pretty universal and standard, though I know that the participants on this webinar are spread among different geographic locations and have different carriers, as well as different funding arrangements for their health plans. So you'll hear me say a couple of times that you'll want to refer to your benefits consultant or your carrier for specific advice or information. We'll start by reviewing eligibility and coverage. So when you're returning employees to work, you will need to determine the waiting period to reinstate coverage after the leave. Many carriers have decided to waive any waiting period for employees who are covered previously and returning to work. Again, you should speak with your specific carrier or consultant for details. Also, you'll want to review any eligibility requirements that changed during a period of furlough or layoff and determine if those changes will be revoked, and if so, when. So, for example, a lot of our eligibility rules for our customers changed to allow coverage for employees on furlough, for example. Also, employers who are required to provide paid leave in accordance with the FFCRA, which Diane spoke a little to earlier, you must continue benefits coverage, including employer contributions, exactly as is provided to other active plan participants during the protected leave. There may be a tax credit available, and you can speak more to Diane or your tax preparer. For cafeteria plan changes, that's your Section 125 plan. For the remainder of 2020, employers may choose, but you're not required, to allow employees to make the following prospective election changes, even if they are not clearly permitted under your regular Section 125 rules. That includes electing health coverage if the employee previously waived, revoke any existing election and make a new election to enroll in a different health plan, or move from single to a family coverage tier, or revoke an existing election for health coverage, provided that employee attest in writing that they are enrolled or immediately going to enroll in other health coverage, not sponsored by the employer. Again, that is elective. You can make the choice whether or not to allow such mid-year plan changes. Also, you'll want to consider how your furloughs or layoffs this year will affect employee eligibility next year for companies using the look-back measurement period. And this is mostly for variable hour employees. I do want to remind everyone that there is a break in service rule under that guideline, saying that if the break is less than 13 weeks, then an employee cannot be treated as a new hire for ALE, or applicable large employer full-time status. Next slide, please. Now I want to move on to the rules regarding extended time frames. This just came out, so you may not have seen this yet. So your normal time frames around things like HIPAA and COBRA and some of the ERISA policies have been suspended until after the national emergency ends, plus 60 days. That national emergency has not had a end date set as of today, but once it is, let's say it was set for June 1st, we would then add 60 days to June 1st, and that's when we would pick up with our normal time frames. So some of the areas where this applies is our HIPAA special enrollment notification period. That's when someone changes plan or has a life event during the year. Let's say an employee is married, and then that marriage allows them the opportunity for their spouse to join their plan, or for them to leave their employer plan and go on to their spouse's plan. Normally, that employee has 30 days to notify the employer of that life event. So that period of time, that 30-day window, will be extended. COBRA notifications, elections, and payment deadlines will all be extended. ERISA claim timelines, and this usually most often applies to providers submitting claims to carriers. They have a certain period of time for which they can make those submissions. Those are being extended. And then your ERISA notices, things like your plan documents, etc. They must be provided, even though the time period, the typical time period is extended. You do have to show somewhat of a good faith effort to provide as soon as administratively possible. And then your Form 5500s and your M1s, any of those due between April 1st and July 15th of 2020. The deadline is being delayed to July 15th. As always, communication is key. So you want to make sure that any coverage changes, such as maybe you've added testing for COVID or telehealth benefits or services that may no longer apply to the deductible. Make sure those changes have been incorporated into your communications and possibly your plan documents. I just wanted to note here that you may be able to impose cost sharing for diagnostic testing required by the employer as part of a return to work strategy. Regulations did say that COVID-related or diagnostic testing for COVID must be covered at no cost share or $0 for employees. But if that diagnostic testing, again, is required as a part of your return to work strategy, you may be able to impose a cost share. And then premiums. So if full premiums were paid by the employer during the period of employee leave, you'll need to determine if and how to recover the employee's portion of their premium or their contributions. Again, a note here that adjustments to employees' hours or pay or the employer versus employee contributions for the medical coverage may impact your affordability of coverage and your ability to use the affordability safe harbor. So we're going to move on to spending accounts, pre-tax spending accounts, FSAs, HSAs, and HRAs. There's been a lot of questions surrounding these, so we thought it was important to make a few notes. For flexible spending accounts, or FSAs, as we know, there's health FSAs as well as dependent care, so we'll speak to health first. If contributions were discontinued during a period of furlough or leave, reimbursement is not available through the FSA for qualified expenses that were incurred during the period of leave, unless catch-up contributions are made upon the employee's return to work. Upon return, if the period of leave was within 30 days or less, most Section 125 rules require employees to step back into their previous elections. If the return was beyond 30 days, there's flexibility to allow new elections if allowed by your plan. I'll state again here, you will want to just consult with your FSA administrator on these rules. Employers are permitted to adopt a 2.5 month or up to a 2.5 month grace period or a carryover, which has been increased, or you may increase it to $550. It's currently $500. To participants in your FSA who fail to submit enough claims to use all of their contributions during the year. This question has come up for our clients quite a few times. Employers are saying, well, I set aside a certain amount of money in my FSA expecting that I would have the year that I normally have year after year. My regular physician's visits, maybe I go to the chiropractor with a certain level of frequency, but I've been on lockdown, I've been in my house, I haven't been able to see my physician, so I, in turn, haven't been able to spend my FSA funds. So employers are allowed to make those extensions either through a grace period or extended carryover amount to allow a little more time for employees to spend their contributions. And then the dependent care. Again, we've heard from our clients, people saying, well, I set aside money in my dependent care FSA, assuming my child would be in daycare for the full year. But they've been home with me for the last 2 months, so now I might need to make some adjustments to my election. So if you had employees make changes to their elections when they return to work, you'll just want to make sure that those are visions they want to keep, or if they need to, readjust them. And then a couple optional points here. For plans with a grace period ending in 2020, participants with unused balance at the end of the plan year or the grace period may be given through the end of 2020 to incur and submit for additional claims. Another option is for the remainder of 2020, employers may allow employees to make prospective election changes to begin and increase or decrease their contributions, even if not clearly permitted by Section 125 rules. Again, that is optional whether you make that available. And then just a couple points on HRA and HSA. So for a health reimbursement arrangement, if an employer contribution is being made and was changed during the period of furlough or layoff, you'll need to decide who is now eligible upon returning to work, what funding and reimbursement will be made, and again, communicate those changes accordingly. And HSA is the simplest of all of them. Employers can adjust their contributions if they're making any to an HSA, subject to any contractual or plan document commitments to the employees previously made. Employees, as they always can adjust their contributions during the year. It is noteworthy that individuals will have until July 15th of 2020 to make contributions up to the annual limits for 2019. Normally, that deadline is set for April. It's whenever we file our taxes. And since our tax filing deadline is pushed back, so has the contribution deadline. And just a quick reminder of the 2019 annual HSA limits are listed on this screen. Any questions? My contact information will be listed at the end of this presentation, and I'm happy to help. I'll pass it back to Diane.
Thank you, Megan, very much. John, I want to be conscientious of the time, and I do note that it's 3:47, and we have quite a lot of slides to go through. So let me know if we have additional time, or if we need additional time. I think we can extend anyway our ability. If your organization is like our organization, we're continuing to hire employees. So wanted to make sure that we added a little bit of information with regards to whether or not your organization might be doing recruiting at the present time. And if you are, the EEOC has provided us with some guidance. If you don't know who they are, the Equal Employment Opportunity Commission is a federal organization under the DOL that provides us guidance as far as things like recruitment, what we can and cannot do. So it's important to note that an employer can take an applicant's temperature as part of a post-offer pre-employment medical examination. It's very important, like everything else, doing drug tests, etc. It's always post-offer and pre-employment. An employer may screen an applicant for symptoms of COVID-19 after making a conditional offer, again, post and pre. An employer may delay the start of an applicant who has COVID-19 symptoms that are associated with it, or those that are associated with it, or an employer, a prospective employer, can in fact rescind an offer from an applicant who is going to be or supposed to be a new employee who is not capable of going into the workplace because they've got COVID-19 symptoms. So know that Although we try to avoid it, you can in fact rescind an offer if you've extended one. Again, bottom of the page offers you where this information comes from. Kevin, I'm moving to the next slide. So physical workspaces. It's important when we return to our physical workplaces, employers need to consider all the logistical aspects to prepare the office for the employee's return. As we first talked about today, they should plan on how to maintain a safe, clean workplace so that employees feel comfortable when they come back into work. Now, social distancing is dependent upon, of course, your square footage, the way that your office is set up, the way that your facility is set up. So consider modifying your open floor plans. You want to go ahead and make sure that you've got the social distance of 6 feet or more. You can also go online if you have not already. There are actually calculators in which you can place in the total square footage and put in the 6 foot necessity, and it'll tell you the capability or the capacity of that environment. I actually have some clients who are mapping out 6 foot blocks with tape on the floor in the offices where they are returning so that no one employee should be in another employee's 6 foot box. There are many ways that you can do that. It is fun to be creative, but it is also important to be correct in how you're doing that. I'm sure most of us have seen that in England, they are using the swimming noodle as a social distancer from one person to another. Consider how you're going to do that at your organization. And if you need any assistance from us, we do have a safety expert that can help. Manufacturing facilities. It'll be key to decide whether or not you can, in fact, social distance in an environment that is inclusive of manufacturing. If you have heard recently in the news, Amazon said that going forward, they have ensured that their employees have every precaution in place, and it is their intent to fire employees who are intentionally violating the social distancing guidelines, because, of course, with each of these things that we are putting into place also comes the responsibility to hold people accountable to doing that. Consider separating desks and workstations. Do you have separators? Do you have plexiglass separators that we are seeing coming up at, say, a CVS or even your doctor's office? The separator from one employee cubicle to another cubicle or a desk to another desk that allow your employees to have safe distancing while also having a barrier to ensure that COVID-19 ability is at least limited within that workspace. The thought process has been, how do we clean those barriers? Again, the plexiglass being better received than the fabric, because the challenge with the fabric was, how are they going to be cleaned? And adjusting your employees' schedules. You can certainly do so, as we've talked about a few times today, to make sure that if your space is small, that those employees who are in the office have enough distance between them. The trick will be in switching employees from their desk to another employee's desk. I would strongly encourage you not to do that because that may lead to additional concerns from that employee that another has been at their desk, and making sure that it's cleaned properly afterwards. Common areas. It will be important to make sure that employees are wearing masks, especially in common areas. There has been discussion about the necessity to wear masks in cubicles that are properly separated, as well as closed door offices. I encourage you to speak with your facilities, speak with your internal staff to decide as an organization what you will be doing. My organization will be wearing workplace masks 100% of the time, regardless of where your office is located. So closed door offices will also wear masks. Kevin, I'm moving to the next slide. So physical workplaces, your high touch surfaces. Are they going to be cleaned by the hour? Are they going to be cleaned, 2 to 3 times a day? Or are you going to let your employees know that these are going to be cleaned in a manner that is consistent with the CDC regulations? Be careful about indicating that you're going to clean something 1, 2, 3, 10 times a day, because you will have employees who are counting. And it's important that you follow CDC guidelines. If you take a look at the pictures that I've provided you here, the center picture is of greatest interest to me with the front door foot opener. The foot door opener is put on the bottom of a door so that your employee, instead of touching the handle, can put their foot on the foot door opener and drag the door open. That'll eliminate their need to actually touch the door fixtures. I've had several clients that have put that in place. If you take a look on the right-hand side from that picture, you'll see that there is a clock, basically a clock, on the spigot, so that when an employee is washing their hands, that clock starts. Remember, the recommendation for hand washing is 20 seconds of actually washing your hands and then rinsing. So people seem to confuse that the two are joined together. They are not. It is 20 seconds of wash and then rinse. So there's also a countdown clock that I bought for our office. I don't know if my colleagues have had a chance to see it yet, but we bought the countdown clock for our office so that employees are well aware of the 20 seconds that are required. Personal protective equipment, masks and gloves. Will you require them? And if you will require them in your office space, you should make them available to your employees. You should purchase them for your employees. And once you do purchase them, considering the costs, provide the training that is necessary to utilize those protective equipment in a manner that would be useful. We want to make sure that we're able to do that. So, follow guidelines, OSHA's guidelines on PPE. There are certainly some organizations, more than average organizations, who have OSHA guideline standards that are stronger than what, say, an office has. Moving on to workplace signs. Certainly any of the signs that you see here would be useful for your organization to make sure that you are demonstrating your conscientiousness on making sure they are safe in the workplace. So in addition to the employment posters that are required by federal and state requirements, the FFCRA poster, it's the upper right-hand corner one, should be posted and should be available and shared with employees because it has the effective date of April 1st. Employers, like I said, with less than 50 employees may have the option to opt out of that law. So check with your employment attorney, check with your HR team, or give me a call and we'll talk about your situation. The CDC recommends specific posters at work, and those are don't spread germs at work, stay home if you are sick. Your organization should in fact be following the guidelines that are provided by the CDC, the DOL, and OSHA. It's important. The industry that you are in and the layout of your workspaces really dictate your need to place things, let's say, even on the ground, to let employees know that the distance is effective. The visitor alert, I can't speak to enough. I think it's very important that as we bring our employees back to work, we also protect them from visitors who may come to our place of business. And this visitor alert certainly provides that. We do have some clients who are looking to have visitors complete a questionnaire. It is my recommendation not to have visitors who are going to complete a questionnaire, but rather attest to the fact that they are free from any symptoms of COVID, including the fever at 100.4 and above. I'm moving to the next slide. Workplace signs again. So exposure protocol illustrations. We have several examples of posters or flow charts or training segments. It's important that your employees know when they have had exposure, if it's primary or secondary, what they need to do, who they need to contact within your organization. So exposure protocol procedures at the Lyons Companies look like talk to your supervisor first and then see human resources. Most organizations will in fact do the same. Moving to the next slide. So updating your policies and procedures, your employee handbook. Employee handbook updates. Consider addendums to the employee handbook until things settle down a little bit. We're all familiar with the FFCRA having been brought in, for our use this year. It's important to note it started April 1st, but it ends December 31st of 2020, and therefore it won't be available next year at the present time. So after we review this section of the presentation, we can also review policies that will likely be a permanent change and those that will not. But the FFCRA, consider that just as an addendum to any handbook that you have. A pandemic preparedness policy and response protocol is always wise for an organization to develop, and you are developing each and every day, each step within your organization that you are taking to address what is occurring is starting that pandemic policy and preparedness. So document the steps that you have taken, and after careful consideration with your company's expert partners and after a thorough review of the website from CDC, I'll also make available for you and OSHA and the Department of Labor, both federal and state guidelines. I'll make available for you a playbook, a safe work playbook that I received while looking online through Lear. It's an automotive manufacturing facility, and it is made public. It's interactive PDF filled with policies and procedures and protocols specific to their organization, but certainly one that you could utilize within your organization and modify it. A prime concern for HR has been coverage under ADA and violating that act. So as we look to go ahead and move employees back to work, we want to make sure that we're not violating any ADA covered employers. So COVID-19 and ADA. So we talked about those employees who are afraid to return back to work. We talked about those employees who are at high risk. Some of those high-risk reasons are in fact going to fall under coverage for the Americans with Disabilities Act. If you've been in human resources long enough, you certainly know that anytime an employee has a covered disability under the ADA, we need to work with them about the accommodation request that they have provided the organization. So always enter into a conversation with employees to be sure that you aren't violating any guidelines under the ADA. I'm moving to the next policy. So updates for policies and procedures again. Here's a much more extensive slide on what we've been talking about already, the FFCRA. So I don't think I really need to go through this slide all that much, but I do want to look at number 14. How do I know whether I have been employed for at least 30 calendar days by the employer for the purpose of the expanded family and medical leave? Important to note with the FFCRA, the first portion of it is with regards to sick time, and that is up to 80 hours of sick time an employee can receive for reasons specific to their illness or the illness of another person for whom they are caring. They are entitled to receive their full pay up to the amount of $511 or $5,110 capped. So it is up to their 80 hours. Lyons Companies, for instance, we work 37.5 hours. So our up to 80 hours, 2 weeks of coverage, is only going to be 75 hours, and we'll have met the law with regards to the FFCRA and sick pay. The other part of the FFCRA is the extended family medical leave, and that is specific for when an employee needs to take care of their child who is under the age of 14 and unable to go to work, or unable to go to school, or unable to go to childcare or daycare for COVID-related reasons. That enables that employee to be off at 2/3 their pay, up to a maximum of $200 per day, for a total of $10,000. And it can get connected to the sick pay side, where there's the possibility of up to $12,000 in total being paid. Employees who've worked for the organization for 1 day are entitled to sick pay. Employees who have worked for the organization for 30 days are entitled to take the extended family medical leave, so long as the employer has not claimed an exemption under one or both of the sides of the FFCRA. So probably a long conversation with regards to it, but give me a call if you've got questions about it. I can certainly answer them for you. I'm moving to the next slide. So, updates on policies and procedures. So, returning employees back to work. Establish a return to work policy that's based on the CDC guidelines. The CDC guidelines for return to work should clearly spell out who is able to return to work, when they are expected to return to work, and the policy should contain safety expectations of employees when they return, including any need for documentation. Can an employer request a note from employees? Yes, they can, but we've also been advised to consider the strain that our healthcare providers are under at this time. Self-screening options and documentation. I have encouraged most organizations to adopt a policy with an acknowledgement from an employee that they will abide by the policy. And the policy says something like, we will not return to work, I will not return to work should I develop signs or have signs of COVID symptoms, and list those out so that the employee knows, I'm not going to do a daily questionnaire that I'm going to collect as an employer, but rather I'm going to issue a policy that says, don't come back to work if you have any of these signs, call your manager. The second choice an employer has is to go ahead and do a manual daily form, or there are certainly technologies that are allowing you to fill out a questionnaire remotely off of an application, off of something that you could review on your phone, you could review on your computer, and that human resources or those people at your office who have been decided to receive that can collect. So you can also do the daily form. So there's create a policy, have your employees sign off on it. There is a daily form for your employees to go ahead and fill out each day. Be sure to keep those separate. Do not put them together. There's the third option of the electronic form or app that you can use on your phone or your computer in order for your employees to fill it out. So as most of us heard on March 18th, the EEOC said and gave the green light for employers to be able to take temperatures of their employees as a possible business necessity under the direct threat of potential harm, considering that as a strong symptom of COVID-19. Your organization needs to make a decision on whether or not that would be something you would like to have in place. If you do in fact have temperatures taken when an employee is at work or returns to work, please be sure that you have a qualified person taking their temperature, somebody who has been trained, and I strongly encourage you to do that in a private area where an employee isn't embarrassed should they be turned out of the workplace because in fact they do have a temperature, and then the embarrassment and being seen in front of some of their coworkers would not be in an employer's best interest. So try to do it in a private place and respect people's need to have that privacy. Moving on to the next slide. So as employers consider new or updated policies, it's important to find a balance between sound business practices and empathy for the difficult and unprecedented times and experiences that employees have navigated. Consult with your company's professional services team, either legal counsel, human resources, your compliance people, risk management organizations, to address each of the areas that they are well skilled at. We have employees who are residing in nearby states that might have other reopen sets. So I am very close to Delaware, but I live in Pennsylvania. Delaware has started to open up much more quickly than Pennsylvania. Our office is in Delaware, but we have a lot of Pennsylvania employees. So in Pennsylvania, we haven't been given the okay to return back to work from our governor until June 4th. So consider that may cause some angst with your employees, and be prepared to go ahead and address it. Train your managers to empathize with employees without increasing risk. And that will be really important to make sure that you pull in your senior management team and talk about what you will and what you will not provide to employees as far as some advice and getting back to work. Employee assistance programs are really important. Consider whether or not you actually want to have a counselor on site, whether or not your plan allows for a counselor to be on site, even 1 or 2 days a week. I think that because it has been such a trying time and because people do have a lot of anxiety in returning back to work, it's not a bad idea to make sure that you have it available for them, whether it be on your site, by teledoc, or simply through a program that they can use a telephone to call. Communicate with your employees as much as you can. You'll see the picture here of quarantines. So one of our clients actually put together a weekly newsletter of quarantines, and they used it to share information with employees. It was, health information, maybe some of the latest statistics, while they really kept the focus on getting back to work and maintaining contact with their employees. So employees responded very well with it. If your organization continues to telework for a time period, consider other things like maybe doing a scavenger hunt. I know one client did a scavenger hunt, and a lot of employees had a very good time being a part of the scavenger hunt in their own home. Where other places, I know that Megan has a team, the employee benefits team, and I know they did a virtual happy hour. So just something that allows your employees who maybe are off-site to communicate with those employees who are returning back to your work site. Make sure you try to keep that open. I'm moving to the next slide. So my name is Diane Campanile. I'm the Director of Human Capital Management for the Lyons Companies. I've got 25 years of experience in human resources. My formal education, I went to Westchester University, the Wharton School of Business, and I'm currently attending Tulane Law School. I've got my colleague with me, Megan Murphy, Employee Benefits Lead. She has stated that she would certainly be available in order to help with any of these things in the employee benefits arena. And finally, from a safety perspective, we work with a Director of Safety, Matt Forrest, and his contact information is there as well. Kevin, I assume that you are going to close us today, so I'm going to go on mute as you take over.
Actually, I was going to hand it back over to John.
Great.
All right, great. Well, thanks. Thanks for everyone for hanging in there. I know there was a lot of information presented. We kind of went over our time frame, but I think with what we're talking about, there was a lot of good information. And then looking at the number of people that are still here, pretty much everybody hung in there. I haven't seen any questions. I mean, I know we're over, but if people do have any questions, shoot them into the chat box. We can do a couple minutes of questions. I will be sending out the presentation. I'll be sending out a link to the webinar recording. And also Diane, I think, is going to provide us with some additional resources and some additional information that I will be sending out as well. So any last minute questions before we sign off here?
No, good.
I think we're set. Again, Kevin, Diane, and Megan, thanks so much for the great presentations today, and look forward to having you join us to roll out the new programs.
Wonderful. Thanks, John.
Thank you, John.
You're welcome.
Thank you.